Lecture 7 deals with the pretrial process, and this is usually also known as the accusatory process. This is from arrest through the arraignment process. Want to do a quick review. We did this in an earlier lecture, but the U.S. system of justice, we have a dual court system. And the first level, and there's a little bit of difference in here, but if you look at Bay Municipal Court now at the bottom, that's actually Bay Superior Court, and that handles your misdemeanor trials and felony preliminary hearings and arraignments. Then above that, Security Court, the Superior Court of Contra Costa County, that's in Martinez, that handles felony trials and juvenile cases and civil cases. Now, these two courts are trial courts, so they deal with questions of fact, the person do it or not. The two other levels above, District Court of Appeals and Supreme Court of California, only hear appeals on mistakes made in the trial court area. In the federal courts, they also have a U.S. federal district court that's the criminal trial court that's similar to Superior Court in the California level. It deals again with mostly felonies. Well, they're almost all felonies, and the court's used by the FBI, DEA, IRS, etc. Now, if you're found guilty in that court and you feel your rights have been violated, you would submit an appeal to the U.S. District Court of Appeals, the 9th District, which handles California. The other venue or the other avenue to get to the 9th District Court is via the Supreme Court of California. If you're not happy with their decision, you can go into the federal arena and have them look at the appeal. And the highest court in the land would be the U.S. Supreme Court in Washington, D.C., and they're also an appellate court. So pretrial, from arrest to trial or plea. Why do we have pretrials? It's important. It's established in the Constitution, and it's an important component of the justice process because a great deal of the cases are resolved informally at this stage and never go before the courts. Figure 9.1 is a typical outcome of 100 urban felony cases. Now, the thing you have to realize is out of 1,000 cases or 1,000 crimes that are committed, only 100 people are brought to justice. So there's 100 arrests brought by the police or prosecution. Of those, 18 are rejected at screening by the prosecution, 21 are dismissed in court at preliminary hearing, and 6 are diverted or referred to other services. So 55 of the 100 go forward. 3 of them go to trial. 52 of them are disposed of by a guilty plea. The ones that went to trial, of the 3, 1 gets acquitted, 2 are found guilty, including the guilty plea that gives you 54 convictions, and of that, 18 are sentenced to a year or less in jail, 14 are sentenced to more than 1 year in prison, and 22 are sentenced to probation or other conditions. So there's about 54% conviction rate, typically. The booking process. Once you're arrested by the police, they've developed probable cause to arrest you. They book you, and there's a list of possible charges. You have to go through mug shots, photos, fingerprinting, possible participation in a lineup, and the time may be used to develop more information about the case. In California, you have 2 days to bring somebody before a judge. So you could do what we call FI, or further investigate, the first day, and by the close of business the second day they have to go before a judge who'll decide if they're going to be held to answer for the crime. When you bring them before the judge, it's called a preliminary hearing. 2 avenues to review the crime that's been committed, either by a grand jury or preliminary hearing. Preliminary hearing is a presentment before a judge. It's a device for screening cases, and the purpose of the hearing is to determine if there's reasonable grounds to believe that the crime's committed and the defendant that's in front of the judge appears to be guilty of it. Where do preliminary hearings occur? Well, in most states it's municipal court. In California it's the superior courts, and it's done by a judge in that court. People can waive the right to preliminary hearing if they're represented by an attorney, or if they want to enter a plea of guilty and be bound over to superior court for sentencing. The evidence of preliminary hearing must show that there's enough sufficient cause to believe the person should be bound over, that there's reasonable cause or sufficient cause to believe the person committed the crime. Defendant is recommended to the custody of the sheriff or released on bond at that point. Now, if the judge decides that the person is going to be bound over, they direct the district attorney to prepare an information. Now, an information is a list which says count 1, whatever the crime is, count 2, whatever the crime is, and it's filed with the court, and it's very similar to a complaint filed in municipal court for misdemeanor cases. But so the information is usually felonies. And once you have the information and the court process starts, you can't change the content of the information. It stays that way throughout the court process. In arraignment, it's a formal court appearance where the person enters a plea. After the information is read by the court clerk, the person acknowledges the charges and then pleads in response to the charges. The person also is told that they have the right to counsel, they have the right to trial by the court, or which a trial by court is where the judge makes a decision on guilt or innocence, or trial by jury, and of their rights to plead guilty or not guilty. If the person comes into court for the arraignment and they appear to be intoxicated, under the influence of a drug, or hysterical, if the judge does not feel that they can make a competent decision, they could reset the arraignment for 24 hours. If the person comes back and there's no change in their characteristics and they still appear to be unable to make a decision, the judge will enter an automatic non-guilty plea and set a jury trial or appoint counsel for the defendant, because it will afford them all of their rights under the Constitution. On misdemeanor cases, the defendant can enter a plea, enter in abstention, meaning that they're not there. Their attorney could do it for them. This does not occur on felony cases, though. When possible, the arraignments will be held in front of a judge who issued a warrant for the person's arrest originally. Sometimes there are other things that occur. The defendant may be in a hospital or jail, and they may do this over closed-circuit TV where it's recorded and there's documentation, and there's counsel there for the defendant, and also the district attorney and the judge are all on two-way TV connect, or the internet now. The person enters a guilty plea. It's the most common plea. The judge must inform them of their loss of rights, the right to counsel, the consequences and possible sentences, and they must establish that the plea is voluntary. So on a guilty plea, they got to do what they call copping out. The judge asks the prosecutor to advise the defendant of the aggravation of the case, and the officer's report is the basis for what the prosecutor uses. If the report's not clear, then the judge may ask that the officer be subpoenaed and brought before him to testify about the seriousness of the case. Not guilty plea is entered verbally by the defendant or their attorney, automatically entered if the defendant stands mute before the court and the trial date is set, and bail may be considered at this point. If the defendant pleads not guilty, the trial date is set by the court and subpoenas are issued. Then they ask the defendant whether or not they want to have a jury trial or a court trial, and they inform them pertinent constitutional rights that they have. Nollo Contendere is similar to a guilty plea in the defendant state's willingness to accept the punishment of the court, but the difference is that you're not ever saying that you did it. You're not saying you're guilty. So in civil court, if you're going to be sued because of this criminal action, they have to still prove that you did it. If you were to plead guilty, they're going to automatically put you on the stand and say, did you plead guilty to this case? Yes. Give us a judgment of $1 million. If you get on the stand, they say, did you plead guilty? Say, no, I pled no contest. I didn't contest it, but I never said I did it. So in the subsequent civil suit, they're going to have to provide sufficient evidence so that show that you were negligent. After arraignment, if the defendant is non-bailable, they're going to be confined in the county jail pending trial. They're taken by the judge. The order is called a commitment. They're taken by the sheriff on a court order called a commitment, and they're held for trial. In a trial hearing, if there's not guilty plea, it sets the stage for trials, which must be 60 days from the time of arraignment. Now, the defense can consent to a later date, and with good cause, they can extend without the consent of the defense. If they plead guilty, sentencing must occur within 21 days. That also can be waived, and they could be sentenced to state prison or county jail, or it could be reduced to a misdemeanor fine, or they could get probation. with your book, there is a CD-ROM that's an instructional video, and you need to put that into your computer. You need to download the player, and I want you to look at, there's a couple of different scenarios you can go through. One is instrument of death, and in that it's going to take you through a murder investigation. There is another case in there that I don't recall the name of, but it's a case where a prostitute is, I think it's called Lethal Weapon. A prostitute is having sex with customers and not telling them that she has AIDS, and they prosecute her there. What I want you to look at is, it's going to take you through the trial process. Both of these will. So on your own time this week, please look at instrument of death using the CD-ROM that's included with your book. Now, the indictment procedure is different than the preliminary hearing, although it serves the same purpose. An accusation is writing is presented by the grand jury to a competent court charging a person with a public offense. Formation of the grand jury. Under California law, it's composed of 19 persons selected from or within the county. They may be inquire into all public offenses committed or triable within the county and present them to the court by indictment. They also have the power to investigate and subpoena witnesses. The grand jury meets in private sessions, and they have the Superior Court, the Chief Judge, and the Superior Court as their advisor. They work with the District Attorney. It requires 12 votes out of 19 to indict somebody, where in a jury trial, it requires a unanimous vote of the jury to convict somebody. This is different. This is just an indictment to hold them for trial. They file the indictment with Superior Court, and it looks very much like an information. Count 1, count 2, count 3. Then a Superior Court judge issues a warrant for the arrest of the indicted person, and the defendant's arrested and arraigned in Superior Courts on the charge. When the information or indictment is filed with the Superior Court, the trial can proceed once the person has been advised of all of the charges. If the person is found guilty and sentenced to death, then they can receive an automatic appeal in the Supreme Court of California, where they're reviewed and either affirmed or reversed on the death sentence. This diagram basically shows you how a person can come into trial, the pre-trial process. So if you look in the upper left, you have PC to arrest by an officer. They have probable cause to arrest a suspect. They bring them before the judge in a preliminary hearing. If the judge binds them over, they order the district attorney to fill out an information, which is a list of the charges, and then they go to arraignment, where they plead either guilty, not guilty, Nollo Contendere. If they plead not guilty, they go to trial. The other processes go to the grand jury, lower left, and the grand jury reviews the charges and will write an indictment, which is similar to an information, with the list of the counts, and then they go to arraignment, and they plead guilty or not, and if they plead not guilty, they go to trial. Remember this diagram, because for future testing, you may be required to reproduce it. Pretrial motions. It's a request the court that an order be issued and bring about a specific action, like that certain evidence be released or that discovery motions be allowed. Pretrial release. Purpose of pretrial release is to improve the release and detention release and detention decisions, and this is done by a group that will actually come into the jail when somebody's arrested and interview them. And it's a service, they call it OR service or pre-release services. They identify those people that are fit to be released and where it would be appropriate to release them into the community. They also monitor pretrial arrestees to determine that they're upholding their agreement on OR. General pretrial release options. can be a conditional release saying that you can be out as long as you stay away from somebody or you go to work or what have you. Supervised release where there's actually a probation officer watching them. Third-party custody release where they're released to the custody of someone who's responsible for them, or release on recognizance where the judge allows them to go to work and operate in the community as long as they promise that they're going to show up in court. Pretrial release factors include the nature of the crime and the offender, their criminal background, the defendant's cooperation with the investigation to determine whether they're fit for release, impact on the community, and also the victim's opinion on whether the person should be released on their own recognizance. Other things that can happen is a person can be put into diversion. Diversion in California is most used under PC 1000, which states that anyone who's arrested for possession of any narcotic for the first time for personal use can be diverted and go get counseling and treatment. The author talks about what are some of the reasons, the yes and no reasons for does diversion work. On the yes column, he says the defender ends up giving something back to the community, and they're not labeled as a criminal. They're allowed to go and get counseling and get their life together. No, the individual is still stigmatized. It doesn't reduce recidivism, which means that it doesn't mean that the person's not going to come back to the system with a similar problem, and it widens the net of social control, meaning that you have Big Brother looking over your shoulder. Bail, the Eighth Amendment says that you have the right to bail, and it's a sum of money specified by a judge to be posted as a condition of pretrial release, and it can be forfeited if the person doesn't show up for the scheduled hearings. At the court's discretion, bail can be increased or denied to ensure the safety of victims or witnesses. Before conviction, if bail is admissible or they're going to allow bail, defendant may be admitted to bail. So what basically happens is once they're found to be held to answer, at any stage the bail can continue as long as they show up to court. After a conviction upon appeal, there's times when judges will allow the person to go out, specifically if it's a crime where they're imposing a fine only. The fine can be posted as bail while they're appealing the case. If the judgment of imprisonment has been given, then the person has to submit themselves to the execution of the judgment, meaning they turn themselves into state prison. How do you get bail? Well, the most common way is using a bail bonds person, and you see these new shows on TV, Dog Bounty Hunter and a variety of different bounty hunter shows now. If it's $100,000 bail, you post $10,000. It's not refundable. You may have to sign over equity of your house or other valuable commodities. And what it says is that if you're going to post $10,000, they're going to post a bond for $100,000. You do not ever get the 10% back. The $10,000 is the fee that they charge for putting the $100,000 up for you. That's number one. Number two, if you don't come back, don't show up at court, they could send bounty hunters after you, and you have already signed a waiver waiving your rights to search and seizure, so they could basically do anything they want to get you, including extradition. Judge decides on the amount of bail, and they work with the DA and the defense to reach a settlement. It's usually set by seriousness of offense and by the history of showing up for court. If you have, say bail is $10,000 and you have $10,000 and you put the $10,000 up, you get all of that back when you show up to court. So it's a little different than using a bonds person. The bail bondsmen make money off of providing the risk of investment of their bond that you're going to show up. Right to bail. Bail must be reasonable. All defendants have the right to be released on bail, except under PC 1270, which says if the crime is punishable by death, then and the proof of guilt is evident and the presumption is great, then the bail is zero. And there's other times that they will set the bail at zero depending on the seriousness of offense and previous criminal history and the probability of showing up. If the person's been on the run for a long time and they finally get caught, the bail's going to be zero. Reforms to the bail system. Probably the most common reform is a police citation, which allows you to sign your name, promising to appear, and usually you have to have a local address, good ID. It's only on misdemeanors for the most part, and it's also determined by whether or not the offense will continue. If you start an argument at a bar and they tell you to leave and you don't leave, the cops get there and they're willing to cite you on trespass and disturbance of the peace, but you say, I'm going to come back and tear this place up, well then obviously the crime is still being committed and they're going to take you to jail and make you post bail. 10% cash bail, similar to bail bonds, but you get most of your money back. You get 8% back. A lot of cities have been doing this to raise money. They will actually post the bail for you. Bail guidelines. So the preventative detention controversy is based on, the pro is based on the notion that certain offenders will commit crimes while they're on release, and that society has a right to be protected from future criminal acts. The arguments against are it's a form of punishment which is not based on the guilty verdict, it's based on something that might happen. We're going to start talking about plea bargaining, and the thing you got to realize is 90% of all convictions come from plea bargaining. The pros and the cons of plea bargaining. The pros are it reduces the cost for society and getting these people through the court system. It improves efficiency. It can concentrate on serious offenses and avoids pretrial detention and delays. The con side is that it encourages defendants to waive constitutional rights. It results in lesser sentences and sentencing disparity, and may coerce innocent to plead guilty. Factors affecting the decision to plea bargain. Again, the judge looks at the nature of the case, and it's the district attorney and the judge and the defense that negotiate. The defendant's prior record and age, the type, strength, and admissibility of evidence in the case, the attitude of the complainant, meaning the victim. Prosecutors in areas with low populations are more likely to bargain. Concessions of plea bargaining. The prosecutor may offer a reduction of initial charges, reduction of the number of charges, recommendation for lighter sentences, or alter the charges, or help move the case to a more lenient judge. Explicit plea bargaining is where there's direct negotiations between the prosecution and the defense. The defendant agrees to plead guilty in exchange for lesser charges. Implicit plea bargaining is different. The entry of a guilty plea by the defendant with the unspoken but reasonable expectation of a less harsh sentence for saving the court time. This is where they know they got you. They got DNA, fingerprints, blood, everything on you, and you're just going to plead out, hoping that they give you a lighter sentence. A couple cases of interest. In Boykin versus Alabama, said that the defendant must make an affirmative statement that they are voluntarily making a guilty plea. Check your discussion forum for this semester's assignment on this topic. Probably going to look for a current event that deals with either a guilty plea or something to do with plea bargaining. Copping out. This is where the judge asks the defendant a series of questions to determine if they're pleading guilty voluntarily. In this case, Ricketts versus Adamson says the defendants must uphold their plea agreement or suffer the consequences. In other words, the person refused to testify in a trial, and he ended up getting charged with the case even though it had been disposed of. They went back and changed everything. In Alford versus North Carolina, it says that you could still plead guilty and maintain your innocence. Now, this sounds strange, but this usually happens where someone wants to take responsibility for a case in a cover-up to protect someone else. In the Hayes case, it says defendant's rights are not violated by a prosecutor that warns that refusal to accept a guilty plea will result in a harsher sentence. If you look at conviction rates comparing guilty pleas, bench trials, and trial by jury, you will see automatically that the number of the years of sentences that are given are much lower for those people that plead guilty. As a matter of fact, it looks like in most cases, in murder, rape, robbery, aggravated assault, burglary, that jury trial gets you the most time. In drug trafficking, it appears that bench trials get you the most time. And in larceny cases, bench trials and jury trials are about the same. This is a list of your key terms. You can pause this movie to be able to look at these so that you know what we're going to be testing you on. It's the end of this lecture.